Namaste students, I am Hans Kumar Sharma, Assistant Professor, Faculty of Law and Governance, Jayoti Vidyapeeth Women's University, Jaipur. Today we will discuss about the wrongful confinement. Earlier, in our last session, we have discussed about the wrongful restraint. This is a very important section of Indian Penal Code, which is section 340, which defines about the wrongful confinement. So let's start. According to section 340 of the IPC, whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits is said to have committed the offense of wrongful confinement. Again, section 340 of IPC says that whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits is said to have committed the offense of wrongful confinement. We can understand this through an illustration. Radhika causes Anamika to go within a walled space and locks Anamika, and Anamika is thus prevented from proceeding in any direction beyond the circumscribing line of the walls, and so Radhika has wrongfully confined Anamika. We can understand this through one another illustration. Suppose A places man with the firearms at the outlets of a building and tells B that they will fire at him if he attempts to leave the building. Here, A has wrongfully confined B. What are the essential ingredients of the offense of wrongful confinement? The accused should have wrongfully restrained the complainant. Such wrongful restraint was to prevent the complainant from proceeding beyond certain circumscribing limits beyond which he or she has the right to proceed. All ingredients of wrongful restraint must be present in confinement also. So, what are the punishment about the wrongful confinement? Section 342 of the Indian Penal Code states that whoever wrongfully confines any person shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine which may extend to 1,000 rupees, or with both. The classification of this offense is that it is cognizable, bailable and triable by any magistrate. Further, it is compoundable by the person confined with the permission of the court. I shall repeat. Section 342 of the IPC states that whoever wrongfully confines any person shall be punished with imprisonment of either description for a term which may extend to 1 year. Please write down in your notebook, term which may extend to 1 year, or with fine, and which may extend to 1,000 rupees. fine which may extend to 1000 rupees, or with both. With both means punishment of 1 year or fine. The classification of this offense is that it is cognizable and bailable and triable by any magistrate. Means the offense is cognizable and it's bailable and it may be tried by any magistrate. Further, it is compoundable by the person confined with the permission of the court. We can understand this through some cases also. So first, you all write down two cases. We will discuss about the two cases regarding this section. First is State of Gujarat versus Keshav Lal Maganbhai, 1993, CRLJ 248, Gujarat. And another one is State versus Balkrishnan, 1992, CRLJ 1872, Madras. Please write down both the cases, and please I request you, all of you students, that please go to AIR library and study about the case. So in the case of State of Gujarat versus Keshav Maganbhai, it was discussed by the court that for a charge of wrongful confinement, proof of actual physical restriction is not essential. This is very important. For a charge of wrongful confinement, proof of actual physical restrictions is not essential. It is sufficient if the evidence shows that such an impression was produced in the mind of the victim. A reasonable apprehension in his mind that he was not free to depart. If the impression creates that the complainant would be forthwith seized or restrained if he attempts to escape. A reasonable apprehension of the use of the force rather than its actual use is sufficient and important. In another case, in State versus Balkrishnan, the complainant was detained in the police station. When this was brought to court, the accused claimed that complainant was at liberty to go away from the police station at any time. The court remarked that when a citizen enters into a police station, the police officer's authority prevails in the jurisdiction and they entertain it with a rude manner. Court held that the accused committed the offense of wrongful confinement. What are the various types of wrongful confinement? Wrongful confinement for 3 or more days, which is described in section 343. Whoever wrongfully confines any person for 3 days or more shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. The classification of this offense is that it is cognizable, bailable, and triable by magistrate. Further, it is also compoundable by the person confined with the permission of the court. Further, wrongful confinement for 10 or more days. Section 344. Whoever wrongfully confines any person for 10 days or more shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. The classification of this offence is that it is cognizable, bailable and triable by any magistrate. Further, it is also compoundable by the person confined with the permission of the court. Further, wrongful confinement of person for whose liberation writ has been issued. Section 345. Whoever keeps any person in wrongful confinement, knowing that a writ for the liberation of that person has been duly issued, shall be punished with imprisonment of either description for a term which may extend to 2 years, in addition to any term of imprisonment to which he may be liable under any other section of this chapter. The classification of this offence is that it is cognizable, bailable and triable by a magistrate of the first class. Further, this offence is non-compoundable. Wrongful confinement in secret. Section 346. Whoever wrongfully confines any person in such manner as to indicate an intention that the confinement of such person may not be known to any person interested in the person so confined, or to any public servant, or that the place of such confinement may not be known to or discovered by any such person or public servant, shall be punished with imprisonment of either description for a term which may extend to 2 years, in addition to any other punishment to which he may be liable for such wrongful confinement. The classification of this offence is that it is cognizable, bailable and triable by a magistrate of the first class. Further, it is also compoundable by the person confined with the permission of the court. Wrongful confinement to extort property or constraint to illegal act. See section 347. Whoever wrongfully confines any person for the purpose of extorting from the person confined or from any person interested in the person confined any property or valuable security, or of constraining the person confined or any person interested in such person to do anything illegal or to give any information which may facilitate the commission of any offence, shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. The classification of this offence is that it is cognizable, bailable and triable by any magistrate, for that it is non-compoundable. Wrongful confinement to extort confession or compel restoration of property. Section 348. Whoever wrongfully confines any person for the purpose of extorting from the person confined or any person interested in the person confined any convention or any information which will lead to the detection of an offence or misconduct, or for the purpose of constraining the person confined or any person interested in the person confined to the store or to cause the restoration of any property or valuable security, or to satisfy any claim or demand, or to give information which may lead to the restoration of any property or valuable security, shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. The classification of this offence is that it is cognizable, bailable and triable by any magistrate, and it is non-compoundable. Thanks for watching. Namaskar.